Good afternoon, all, and today's video is how Florida Circuit Judges are using a specific autistic immutable trait of black and white thinking and rigid adherence to following the rules to put autistic people on Florida Vexatious Litigant Registry to bar court access. Now, first I want to say that the Florida Supreme Court and its Chief Justice, the Honorable Chief Justice Muniz, are in complete denial that this is actually happening. And the Florida Supreme Court's Task Force number 1 and Task Force number 2 shirked their duty to investigate Florida's Vexatious Litigant Statute in toto in all of its applications when they were assigned under the Chief Justice's order to do so. So now, let's get into it. I'm autistic. I'm autistic by an ASD diagnosis by my Dr. Michael W. Hoffman, MD. Dr. Hoffman based his ASD diagnosis of me on the ADIR gold standard autism diagnostic test, as he references in his emails, in his own words, scoring it, and in his own words called it a, quote, autism diagnosis, end quote. So now, the other thing is that I'm one of the few autistic adults, like Eric Weber in California and Haley Moss in Florida, who went to law school, graduated law school, and passed a bar exam. So, what are we taught in law school? We are taught that we have an obligation to shepherdize and make sure the cases that we are going to tell a court support our legal position, our actions, are the most updated and still valid precedent there is. We're also under an obligation of candor to the court. That is, if there is a binding precedent of a higher court that the lower court is required to follow, we have an obligation to tell the lower court so, and name the case, and oftentimes, if the lower court asks, provide it the case citation. So, now I'm autistic, and I notified Circuit Judge Honorable Monica Brasington that I was autistic. So, she was fully on notice of my disability for purposes of Title II of the Americans with Disabilities Act and her duty to reasonably accommodate my disability, and also not to discriminate against me on account of my ASD disability. So, what happened? Well, my husband and I were in this case. So, in this case here, the Florida Circuit Judge, Honorable Monica Brasington, entered this order. And she states in the order, a hearing was held on April 12, 2017. As you can see, it was a motion to dismiss hearing, a motion to dismiss the complaint filed by myself and my husband. Now, here, the Honorable Monica Brasington says, the hearing on all motions, these are motions to dismiss, was properly noticed for 11 a.m. on April 12, 2017. At 10:40 a.m. on April 12, 2017, the plaintiffs filed a first amended complaint for damages declaratory and injunctive relief. The Honorable Monica Brasington said, the court has authority pursuant to Florida Statute Section 68.093 to require vexatious litigants to post security under certain circumstances. The court also has the inherent authority and duty to limit abuse of the judicial process by pro se litigants. The court then found that the Patronos, by their conduct, have exhibited a disregard for and an abuse of the judicial process. Okay. So, what's the cardinal sin as an autistic person that I committed upon the Circuit Judge Honorable Monica Brasington's court that was an abuse of the judicial process that allowed her to label me as a vexatious litigant? Well, she says that it was that my husband and I filed a first amended complaint about 15 or 20 minutes before she convened a hearing on defendant's motion to dismiss the initial complaint. This wasn't a motion to dismiss our newly filed first amended complaint. And in the docket of the case, it's absolutely provably clear on the face of the docket that no defendant in the case had filed an answer pleading. So, I can't speak for my husband, but what did I do as to myself? Now, I graduated from law school with a Juris Doctor degree with extensive legal training. I passed the hardest bar examination in this country, the California Bar Examination, which actually certified that I had more knowledge in the law than someone like the Circuit Judge Honorable Monica Brasington, who passed a less strict and less hard bar exam, the Florida bar exam. So basically, I had more knowledge about the law than the judge had. So, then what happened? Well, I did what I was taught to do in law school. I did legal research to find out if there was a case on point to my being able to file a first amended complaint without asking for leave or permission from the court, from the judge. And when could I file it, up to when? What would be the time deadline? Well, I found this case. Bokeberger, Inc. v. Forum, 2005, Supreme Court of Florida, number SCO1-1830. Here it's directly on point to what I did. Bokeberger is the appealing party here, but they were the defendant in the circuit court below. Bokeberger scheduled a hearing on its motion to dismiss. On the morning of the hearing, Forum, the plaintiff, through new, though not substitute counsel, filed an amended complaint without leave of court. Okay, so far so good. I'm autistic, but my legal research did me good. I found a Florida Supreme Court case directly on point to what I did, and it was binding on the circuit court and Honorable Monica Brasington, which is a lower court. So, was this okay to do this or not? Well, just like Judge Brasington, the circuit judge in this case was whining and complaining. Turning to the issue of amending the complaint without leave of court, the trial judge next noted that the hearing had been set for nearly 4 weeks and that the amended complaint had been filed only on the day of the hearing. Just like I did, the plaintiff's counsel in Bokeberger pointed out that the rules permit an amendment without leave of court before a responsive pleading is filed. That would be an answer pleading. And that the pending motion to dismiss was not responsive pleading. So in Bokeberger, the circuit court trial judge did exactly what Judge Brasington did. The trial judge thereupon announced that he would proceed with the hearing for an argument on the pending motion to dismiss, but only as to the initial complaint. The judge added that he would not recognize the amended complaint as filed. And therefore, the same as what Judge Brasington did, the outcome was that the court granted the motion to dismiss with prejudice. And so the Florida Supreme Court, in its analysis, addresses the right to amend a complaint. The Florida Supreme Court notes that under Florida Rule of Civil Procedure 1.190, a party may amend his pleading once as a matter of course at any time before a responsive pleading is served. This rule has not yet been construed as depriving a trial court of discretion to withhold leave to amend a pleading to which no response has been served. Rule 1.190 reads in its entirety, a party may amend a pleading once as a matter of course at any time before a responsive pleading is served, or if the pleading is one to which no responsive pleading is permitted and the action has not been placed on the trial calendar, may so amend it at any time within 20 days after it's served. Otherwise, a party may amend a pleading only by leave of court or by written consent of the adverse party. So the Florida Supreme Court states, thus by its terms, the rule provides for amendment as of right, first sentence, and amendment by agreement or leave of court, second sentence, depending on the circumstance. The Florida Supreme Court further states, a judge's discretion to deny amendment of a complaint arises only after the defendant files an answer or if the plaintiff already has exercised the right to amend once. The Florida Supreme Court further states, as the 4th District held, a court has no discretion to deny an amendment under the first sentence of the rule. The Florida Supreme Court concludes, we approve that part of the district court's opinion holding that a plaintiff has an absolute right to amend the complaint once as a matter of course before a responsive pleading is served. It therefore follows that leave of court is unnecessary to amend a complaint for the first time before the defendant has filed an answer. Okay, so that is the binding precedent that bound what the Circuit Judge Honorable Monica Brasington could or could not do. So here we see that she is whining, just like square on point in that binding Florida Supreme Court decision, whining that I filed the first amended complaint 15 or 20 minutes before the defendant's motion to dismiss hearing on the initial complaint. The defendants, as face of the docket proves, never filed any responsive pleading, i.e. answer. Under this Florida Supreme Court binding precedent, I had the absolute right to file my first amended complaint at any time up until Circuit Judge Honorable Monica Brasington commenced the motion to dismiss hearing. Okay, so then what happened? Then what happened is Circuit Judge Honorable Monica Brasington doubled down in this case and entered a second vexatious litigant order against me. In this case, she stated about the plaintiff's continuing pattern of behavior in this case and the other case involving me of pleadings filed on the eve of hearings, trial, creating a situation that requires court intervention. She then says the plaintiff by her conduct has exhibited a disregard for and an abuse of the judicial process. Okay, so do you get that, what she did? Circuit Judge Honorable Monica Brasington, after she utterly blew off and refused to follow binding Florida Supreme Court precedent in Bocaberger v. Forum that said in the first case we talked about that I had an absolute right to freely amend my complaint at any time up until her motion to dismiss hearing because the defendants had not filed any responsive pleading or answer. And that's what I did. So, Judge Honorable Monica Brasington was so PO'd about interacting with my autism and her unnatural aversion to my autism and hostility that she was out for blood. So what she did is in a second case, she entered a second vexatious litigant order. So the first vexatious litigant order is entered upon the basis that she is blowing off binding Florida Supreme Court precedent upon her and failing to follow the rule of law. Okay? Because if she followed the rule of law set forth in Bocaberger v. Forum by the Florida Supreme Court, she could not have used that to put me on a vexatious litigant registry because I was following the rule. But she was looking for any reason to screw me because I'm autistic and put me on this registry to bar all my court access. So the means she used to do so is she blew off Florida Supreme Court binding precedent upon her. But that wasn't enough. So she goes into case number 2 and she cites the fact that I did that in the first case we talked about, followed the rule of Bocaberger, and filed a First Amendment complaint on the eve of her hearing, 15 or 20 minutes before her motion to dismiss hearing, and that abused the courts because somehow, even though licensed Florida bar members can follow that rule and do exactly what I did and not get in any kind of trouble. Oh no, when it comes to me, an autistic person who has the same legal education as the Florida bar member, and I passed a harder bar exam than the Florida bar members. So I passed the bar exam, they passed the bar exam. So we're sort of similarly situated, but in any event, I had the same obligations a Florida bar member would have. And when the rule says that a Florida bar member can do what I did and not get named as a vexatious litigant, then why is it that when I'm autistic, suddenly this Circuit Judge Honorable Monica Brasington is flip-flopping and saying, oh, you don't get to do what licensed Florida bar members do. Oh, no, I'm going to treat you differently. Why? Because you're autistic. That's why. And so in case number 2, she enters a second vexatious litigant order against me for obeying the rule of law, for doing competent legal research and finding the Bocaberger v. Forum case that's square on point to what I did in case number 1. That is filing a first amended complaint on the eve of her motion to dismiss hearing when my right to amend was absolute and freely allowed. So I didn't do anything wrong. I didn't do anything wrong. The sole thing she didn't like is that I'm autistic. That's the sole thing she didn't like. So in case number 2, she enters a second vexatious litigant order, citing that as the reason. So a Florida bar member who's neurotypical because As far as I know, Haley Moss is the only Florida bar member out of 111,000 bar members in Florida who is autistic. So hence you can reasonably calculate that the rest of them are neurotypical. These neurotypical Florida bar members can do exactly what I did and not get in any trouble at all, and not get named to a vexatious litigant registry and completely banned from access to the courts. But because I'm autistic, well, I got treated differently by Monica Brasington, the Honorable Circuit Court Judge. But now, the Florida Supreme Court's Task Force number 1 and 2 on vexatious litigation, they didn't really investigate what's really going on at all. They only did neurotypical superficiality. But they didn't do what the Chief Justice charged them with doing, which is to investigate Florida's vexatious litigation statute. If they had, they would have figured this out, because my cases were reported and cases that they would have had to investigate. So now, can a Florida Circuit Judge put an autistic adult on Florida's Vexatious Litigant Registry simply because that adult is autistic? Well, yes, and the Honorable Monica Brasington did so. How do we know that? Well, because as simplypsychology.org states, black and white thinking in autism, and this is the article here, black and white thinking, also known as all or nothing thinking or dichotomous thinking, is a common cognitive pattern in autistic individuals. What does black and white thinking in autism include? Expecting everyone to follow the rules. Rigid routines and the one right way to do things. An autistic person might insist on doing a task the exact same way every time and believe any other way is incorrect. So, if there is this rule that is in binding precedent set forth by the Florida Supreme Court and in the Florida Rules of Civil Procedure, that a plaintiff can amend their complaint at any time up to a motion to dismiss hearing, if the defendant has not filed an answer yet, then the autistic person is going to follow the rules and expect everyone else to follow the rules, and is going to be rigid and think that there's only that one right way of doing things. The autistic person is not going to start thinking, well, should I do things and follow the rule? Is that the right way for me to do things? No, because the autistic person has rigid thinking. The autistic person has black and white thinking. The autistic person, if there is a rule set down for everyone, the autistic person is going to obey and follow that rule and expect everyone else is going to follow that rule, such as the Circuit Judge Honorable Monica Brasington and the defendant's lawyer, Richard H. Fabiani, Esquire. Literal interpretation of rules and fairness. Many autistic people have a strong sense of justice and fairness reinforced by black and white thinking. They may expect everyone to strictly follow stated rules and social norms. If someone, even an authority figure, behaves unfairly, the autistic person finds it intolerable or baffling. Autistic people also have difficulty with unexpected changes. One of the primary challenges is difficulty with change in unexpected situations. When things are rigidly categorized, adapting to new circumstances or deviation from routines or rules can be extremely stressful. It's exactly what the Honorable Monica Brasington did. She threw an unexpected situation and deviated from the rules set forth by the Florida Supreme Court. From a psychological perspective, black and white thinking in autism is often rooted in how the autistic brain handles information and uncertainty. Intolerance of uncertainty. Research and clinical observations show that many autistic people have a low tolerance for uncertainty or ambiguity. In response, an autistic person might develop a habit of categorizing things rigidly as a coping mechanism. And this article was by this author here and can be found there. So clearly, in light of that knowledge, which Circuit Judge Honorable Monica Brasington knew or should have known, because the ADA coordinator would have been required to know that and should have advised the Honorable Monica Brasington of that. The Honorable Monica Brasington put me on Florida's Vexatious Litigant Registry on account of one of my immutable and invidious autistic traits. Oh, can you put somebody on a vexatious litigant registry and enter vexatious litigant orders against them on the basis of a particular disability, autism spectrum disorder, and because of that person's immutable and invidious autistic trait? Can you do that without violating Title II of the Americans with Disabilities Act? What's more, under the diagnostic criteria in the DSM V TR Autism Spectrum Disorder Diagnostic Criteria 299.00, Criterion B, restricted repetitive patterns of behavior, interests, or activities as manifested by at least two of the following, currently or by history. Examples are illustrative, not exhaustive. See text. Number 2, insistence on sameness, inflexible adherence to routines or ritualized patterns of verbal or nonverbal behavior, e.g. extreme distress at small changes, difficulties with transitions, rigid thinking patterns, greeting rituals, need to take same route or eat same food every day, black and white thinking, and following the rules falls under that DSM V TR ASD Diagnostic Criterion B.2. So what does that mean? Well, that means that the Honorable Monica Brasington, Circuit Judge, put me on Florida's Vexatious Litigant Registry directly because of one of the DSM V TR diagnostic criteria for autism spectrum disorder that I met, Criterion B.2. So, it doesn't matter what Task Force number 1 and 2 on vexatious litigation assigned to investigate Florida's Vexatious Litigant Statute has to say in their reports. The fact is, circuit judges are putting autistic adults on Florida's Vexatious Litigant Registry on the basis of specific DSM V TR autism spectrum disorder diagnostic criteria that are part of the person's ASD diagnosis. Is this right? Is this wrong? Are they allowed to do this? Is this constitutional? Well, it sure as heck violates Title II of the Americans with Disabilities Act. Oh, say, does Florida's Vexatious Litigant Statute, Section 68.093, violate Title II of the Americans with Disabilities Act as amended on its face? Wow! It does! Wow, you don't say. Well, I produce these videos to bring more awareness to autism spectrum disorders, to autistic people, and more appreciation of autistic adults, and to help bring about needed change in the way the United States and certain states in our country, such as California and Florida, are treating autistic adults. If you like my videos, please hit the like button. And also, please hit the subscribe button and ring the bell, and you'll be notified of my future videos. And thank you for watching.